If the offence of bribe is committed, then the person shall be punished with 1 year imprisonment or fine, or with both. If the offence of affray is committed, then the person shall be punished with 1 month imprisonment or fine, or with both. If the offence of voluntary hurt is committed, then the person shall be punished with 1 year imprisonment or with fine amounting rupees 1000, or with both. If the offence of theft is committed, then the person shall be punished with 3 years imprisonment or fine, or with both. To remain silent after tolerating injustice is a great misdemeanor. Justice means even to punish your friend is your duty. Whenever criminal activity is committed, either knowingly or unknowingly, punishment is sentenced in the form of imprisonment or fine. But has the nature of punishment been described somewhere in writing? If yes, then where? Is the same type of punishment given for all types of criminal activities? From where did we derive the process of punishment? Hello, I am Gaurav Mathur and you are watching Law World's Knowledge Heritage. I hope you and your family are doing well. I heartily welcome you all in our today's discussion on the topic penal laws and punishment. The process of punishment and justice is going on since ancient times. The struggle against injustice has been going on since from the very beginning. About 4000 years ago, from the reign of King Sargon of Akkad, a kingdom of Mesopotamia, the king is considered as basis of punishment and justice in the absence of law. But the fact cannot be denied that man is a social being and selfish tendencies are inherent in them. These selfish tendencies gives birth to many type of disputes and discord. And if it is not controlled, then these tendencies may lead to anarchy and disorder in the society. Human beings has to protect their body, property and reputation by their own. Keeping this in mind, penal law was created. Penal law was sprouted from the time of sage Manu, Yajnavalkya and Narad. They have described the punishment into their Dharma Shastras. Even sage Manu has described the punishment and divided the crime in his book called Manusmriti into Mahapatak, the great sin, Anupatak, the rational crime, and Uppatak, the misdemeanor offense. Moreover, the harshest punishment has also been described into it. In this video, it is not possible to mention the brief and detailed history of penal laws, but it wouldn't be appropriate if the important ones are not mentioned. The first stage of discussion describes history of penal law from 1792 to 1750 BC, during which Babylonian law was formed during the reign of Hammurabi. The Babylonian method is also called Hammurabi method or cuneiform method because in 1750 BC it was written on cuneiform script. As for sake of absence of facilities like modern paper, pen, etc. like today we have. In Babylonian law, crime is punished and defined on the basis of regular criteria. But perhaps the first error of this law would have been that the punishment in it is very cruel, and the second error would be that it is not clear that the offense is considered to be an injury to a particular person or to the state. In the second stage of discussion, describing the history of penal law from 1753 BC to 5th century AD, it was found that during this time, Roman penal law was created in Rome. Under Roman penal law, the crime is divided into three parts, showing the antithetical form and disorderly form. Publica judicia. It includes such offences which are prohibited by specific law. Extraordinary criminal offences which have no mention in the specific law and are left to the discretion of the criminal court come under this category. Private delicta. Such offences are included in this class in which the right to proceed against the injured party has been given. The third stage of discussion was obtained while studying the years 1526 to 1761. During this period, the reign of Mughal invader was going on in India, which is also known to be called as a golden bird, and during this time, the creation and establishment of Muslim penal laws was done through them. Muslim penal law included many types of error or loopholes within itself, such as the principles of this law were not in accordance with natural justice and common sense, extremely harsh, archaic, cruel, and resulted from the fanatical religious ideas. The Muslim penal law divides the punishment given for different types of crimes mainly into four parts. Kisa, crime in which there is a provision for retribution or revenge, comes under this category. Diya, offences that provide for the value of blood, are included in this category. Had, antisocial or anti-religious crimes, comes under this category. Tajir, crimes whose punishment was imprisonment, banishment, corporal punishment, punching on the ear, or any other confusing conversation, comes under this category. The fourth stage of discussion has been seen in the year 1600. The establishment of East India Company and its ongoing rule in India, and the creation of the British era penal law by it. It is said that during its reign many charters and acts were passed in the Muslim penal law. Various reforms and changes were made, of which the important ones are of 1600, 1609, 1661, 1668, 1672, 1683, 1687, 1726, 1783, 1875, and etc. After this, the Indian Penal Code was presented with the important contribution of Warren Hastings, Lord Cornwallis, and William Bentinck. The most important destination of our discussion was starting from 7th October 1860. During this period, the present longevity and important penal law, the draft of Indian Penal Code, was prepared by President Lord Macaulay of First Law Commission and passed on 7th October 1860. Initially, this code was aggregating of 488 sections, but it kept on increasing from time to time by amendments, and presently it is consisting of 511 sections. After this, 228A, 376A, 376B, 376C, 376D, and 498A have been newly added with the intention to strengthening the laws concerned with the rape sensitive offences by the Criminal Law Amendment Act 1983. As far as it is concerned with the merits and demerits of this code, it is considered the ideal model of legislation and permanent gift of Lord Macaulay's genius and diversity. If you have watched the video till now, hope you liked it. Please motivate and encourage us by pressing the like button below given. Thereafter, to become our family member and to get more such videos in upcoming periods, do subscribe our YouTube channel. Don't forget to click the bell icon and choose the all option. With this, asking for the leave. Hope to meet you very soon on the next topic of discussion with a new zeal and enthusiasm.